Hello students, this is Dr. Rajmugli Amri Shetty, practicing company secretary, corporate legal advisor and insolvency professional. Being insolvency professional, appearing before National Company Law Tribunal and also author of book on lectures on insolvency and bankruptcy laws. I am confident to properly elucidate this topic and I am glad to be part of this knowledge sharing mission. In this part of lesson, we will learn about the implementing agencies, that is 4 pillars on which the entire ecosystem of IBC rests upon. The 4 pillars are: 1. The Insolvency and Bankruptcy Board of India, which is called IBBI. The second one is Insolvency Professional Agencies, which is called IPAs. The third one is Insolvency Professionals, IPs, including Insolvency Professional Entities, IPEs, and Information Utilities, that is called IUs. Regarding registered valuers and another instrumentality in effective implementation of IBC, we are not able to cover in this lesson because of paucity of time. We will learn about some of the key aspects of these implementing agencies. Students, part 4 of the code deals with regulation of insolvency professionals, agencies and information utilities, that is called as implementation agencies. Let us first discuss about IBBI, which is called Insolvency Bankruptcy Board of India. Chapter 1 and 2, sections 188 to 198 of part 4 of IBC deals with constitution, powers and functions of IBC. It is not exaggeration to say that IBBI is a key pillar of ecosystem responsible for successful implementation of IBC and is vested with numerous roles and responsibilities, which includes regulating the professionals, professional agencies like IPs, IPAs, IUs and RVs, as well as various processes also. It may be noted that the preamble of the code itself specifies the establishment of IBBI. The preamble reads that it is a code to consolidate and establish an IBBI and for matters connected therewith or incidental thereto. This itself shows the intent of the code and importance given to IBBI. Now, let us first understand the important provisions of IBBI. Now, section 188 to 195 deals with modalities of functioning of IBBI. According to section 188, IBBI is a body corporate having perpetual succession, common seal, hold and dispose of movable or immovable property, and it can be sued and be sued on its own name. The provisions regarding IBBI were enforced effective from 1st October 2016. Now, let us understand constitution of the board of IBBI. As per section 189, the board shall consist of: number 1, first person is chairperson plus 5 members to be appointed by the central government, of whom at least 3 shall be whole time members, plus 3 ex officio members not below the rank of joint secretary to the government. Out of these ex officio members, 1 each to be represent Ministry of Finance, Ministry of Corporate Affairs and Ministry of Law, plus 1 member should be nominated from RBI. The chairperson and members shall be persons of ability, integrity and good standing. The term of the chairperson members shall be for 5 years or till they attain the age of 65 years, whichever is earlier. The selection committee for selection of chairperson shall consist of chairperson equal to cabinet secretary rank plus expert members of repute plus secretaries to Government of India. Section 190 deals with removal of members from the office. That is, the central government may remove a member from office if he is undischarged bankrupt or physically or mentally incapable of acting as a member or convicted of an offence which in the opinion of central government involves moral turpitude or abused his position as to render his continuation in office detrimental to the public interest. Section 191 states that the board chairperson has powers of general superintendence and direction of the affairs of the board plus other delegated functions by the board. Section 192 deals with the procedures regarding meeting of the board. Section 193 enunciates that interested director shall not participate in the board meetings. As per section 194, no proceedings of the board shall be invalidated merely because any vacancy or defect in constitution of the board or any defect in the appointment of board member or any irregularity in procedure of the board not affecting the merits of the case. IBBI and central government floated various rules and regulations governing personnel, accounts and board meeting related matters and also for administrative convenience. Section 196 to 198 deals with the powers and functions of the IBBI. As per section 196 and subsection 1, subject to general direction of the central government, IBBI controls insolvency professional agencies, insolvency professionals and information utilities by way of registering, renewal, suspension, cancellation of such registrations, and promote development and regulate the practices of such agencies, and specify minimum eligibility requirements for registration, levy of fee and other charges for carrying out purposes of this code. Specify regulations for minimum standards for the said agencies, lay down curricular to conduct examination for becoming insolvency professionals, monitor performance, call for information from the said agencies, issue necessary guidelines, conduct periodic studies, research and audit of said functionaries and also specify mechanism for redressal of grievances. Further, IBBI may enter into MOUs with any other statutory authorities and maintain website and such other universally accessible repositories of electronic information. IBBI promote transparency and best practices in its governances and perform such other functions as may be prescribed. As per section 196 subsection 2, the board may make model bylaws to be adopted by insolvency professional agencies which may provide for minimum standards for professional competence, ethical conduct of the members, requirement for enrollment of persons as members which shall be non-discriminatory, manner of granting membership, setting up of governing board for internal governance and management and fair and transparent mechanism for redressal of grievances and the manner and grounds on which penalties may be levied, grounds on which IPs may be expelled. Further, IBBI may regulate manner of conducting the examinations, duties and other activities to be performed by the members and manner of conducting disciplinary proceedings against members and also the manner of utilizing the amount received as penalty imposed on insolvency professionals. As per section 196 subsection 3, while exercising powers under the code, IBBI shall have same powers as are vested in civil court under Civil Procedure Code 1908 while trying any suit in respect of following matters, that is discovery and production of books of accounts and other documents, summoning and enforcing the attendance of persons and examining them on oath, and inspection of any books, registers and other documents, issuance of summons for examination of witnesses or documents. Conferred with the powers under section 197, the board may constitute advisory committees, technical committees, disciplinary committee and internal complaints committee. Students, now let us discuss about the second pillar of IBC, that is Insolvency Professional Agency. Part 4, Chapter 3 under section 199 to 205, read with rules, IBBI model bylaws and governing body of IPAs regulations 2016 and IBBI Insolvency Professional Agencies regulation 2016 deals with insolvency professional agencies. Now, let us understand the procedure for registration. Only the companies registered under section 8 of the Companies Act can approach IBBI for registration as IPAs, which will lay down professional standards, code of ethics and be the first level regulator for insolvency professional members. The requirements for registration are that this section 8 company shall have net worth of at least 10 crores and minimum paid up capital of 5 crores. It shall not be under the control of NRIs, that is not more than 49% directly or indirectly held by NRIs. Should not be a subsidiary of a body corporate and its applicants, promoters and directors and shareholders are fit and proper persons. However, a statutory regulator like the Institute of Company Secretaries of India may hold 100% of paid up capital of the IPS. Now, procedure for registration. A proposed IPA shall submit Form A along with proof of payment of rupees 10 lakh towards a registration fee. Once registered, it is valid for 5 years. For renewal, again rupees 5 lakhs has to be paid and submit Form A 6 months before expiry of such registration. Bylaws to be enclosed along with Form A, which shall be as per model bylaws. IBBI to grant license in Form B within 60 days of submission of Form A with the requisite fee and documents. Now, procedure for rejection by the IBBI, if any. After considering the application, if there is a prima facie opinion, the registration or renewal ought not be granted, give applicant an opportunity to explain within 45 days of receipt of application, to explain within 15 days. Thereafter, IBBI may accept or reject within 30 days of receipt of such application. Now, upon the action of the IBBI, an appeal can be filed before NCLAT, that is National Company Law Appellate Tribunal. The governing body of IPS shall consist of managing director, independent directors and shareholder directors. More than 50% of directors shall be residents in India. Number of IDs, that is independent director, shall not be less than shareholders directors, and no meeting of general body shall be held without the presence of at least one independent directors. Standards, qualifications have been prescribed for independent directors and managing director. IPS exercise the following powers, that is grant membership as insolvency professionals to persons who fulfill all requirements set out in the bylaws on payment of membership fee, safeguard the rights, privileges and interest of its member insolvency professionals, suspend, cancel membership of insolvency professionals on the ground set out in the bylaws, lay down standards of professional conduct and monitor performance of its members. It is pertinent to mention that there are only 3 IPAs at present in India. They are Indian Institute of Insolvency Professionals of ICAI. Second one is ICSI, Institute of Insolvency Professionals. The third one is Insolvency Professional Agency of Institute of Cost Accountants of India. Students, let us now discuss about the third pillar of IBC, that is Insolvency Professional. Part 4, section 206 to 208 deals with insolvency professionals, including insolvency professional entities. Insolvency professionals are instrumental mainly in execution of CIRP, liquidation process, and also play vital role in bankruptcy, and they are front officers in implementation of IBC. Let us understand the provisions regarding insolvency professionals. That is, what are the requirements to be an insolvency professional. An individual intending to be insolvency professional shall be an individual member of the insolvency professional agency and registered with the IBBI. Now, what are the eligibility criteria for registration as IP? No person shall be eligible to be registered as IP, that is insolvency professional, if he is a minor or is not a person resident in India and does not have qualification and experience as per regulation 5 and 9, and if he is convicted for offence with imprisonment exceeding 6 months or convicted for offence involving moral turpitude and a period of 5 years not elapsed, and if convicted for a period of 7 years or more, he shall not be eligible at all. And if he is undischarged insolvent in unsound mind status and is not a fit and proper person. A person shall be eligible for registration if he has passed national insolvency examination or passed limited insolvency examination plus 15 years of experience in management after graduation, or passed limited insolvency examination plus 10 years experience as member of ICAI or ICSI or ICWAI or Bar Council with prescribed pre-examination training, or enrolled with IPA and registered with IBBI. And the process of registration is that the individual for enrollment with IPA to submit Form A to IBBI within 12 months of passing the examination and pay rupees 10,000 as non-refundable fee. IBBI may call for additional information and if satisfied after inspection or inquiry grant certificate of registration in Form B within 60 days of receipt of application. Then he shall pay rupees 10,000 for every 5 years for renewal and pay to IBBI a fee calculated at 0.25% of the professional fee earned before 30th of April every year and submit statement in Form E. If not paid on time, applicable interest is 12% per annum. And he shall take permission of the IBBI before shifting from one IPA to another IPA. He shall maintain records of each assignment for at least 3 years. Refusal to grant registration. After submission of Form A, IBBI is prima facie opinion that registration ought not be granted. It shall serve notice within 45 days of receipt of application, which shall be replied in 15 days. IBBI shall form an opinion and accept or reject within 30 days of receipt of such application and communicate to the applicant. Disciplinary proceedings based on the findings of inspection or investigation. If IBBI is of prima facie opinion that sufficient cause exists, It shall issue a show cause notice along with material relied upon. IBBI shall constitute disciplinary committee which shall endeavour to complete the action within 6 months. A copy communicating the order shall be given to Insolvency Professional Agency and shall be published on the website of IBBI. The order passed shall become effective after 30 days. The code of conduct for the IPs is that the IPs shall take reasonable care and diligence while performing his functions. He shall comply all the requirements specified in the bylaws of IPA of which he is a member. He shall allow IPA to inspect his books or records. He shall submit records of every proceedings before the adjudicatory authority, IBBI and IPA of which he is a member. He shall perform his functions in such manner and subject to such conditions as may be specified. He shall comply with all the requirements as mentioned in Schedule 1 of IBBI Insolvency Professional Regulation 2016. Now, let us discuss about insolvency professional entity. An LLP, registered partnership firm or a company may be recognized as IPE, that is insolvency professional entity, if the sole object is to provide support services to insolvency professionals. Net worth of such entity is not less than rupees 1 crore and majority of capital is contributed by the directors and partners. Registration process. Application for registration to be submitted in Form C along with proof of payment of fee of rupees 50,000. If the IBBI is satisfied, it may grant certificate in Form D. The insolvency professional entity shall inform change in the directors or partners within 7 days with a fee of rupees 2,000 in Form G. IPE shall be jointly and severally liable for all acts or omissions of its partners or directors. The IBBI may de-recognize the IPE by passing a reasoned order. Now, students, let us discuss about the other pillar of IBC ecosystem, that is information utility. Part 4, Chapter 5, Sections 209 to 216, read with IBBI Information Utilities Regulations 2017, deal with information utilities. An information utility shall provide such services as may be specified, including core services like collecting and storing information on debts and defaults to any person, if such person complies with the terms and conditions as may be specified by regulations. No person to function as information utility without certificate of registration. Now, what are the preconditions for registration? Number 1, the proposed information utility should be a public limited company. 2, the sole object of such public limited company shall be to provide core services and other functions as may be necessary. And minimum net worth of such public limited company shall be rupees 50 crore and the promoters, directors, key managerial person and persons holding 5% or more share capital of such public limited company shall be fit and proper persons. The registration procedure is that application for renewal shall be submitted in Form A along with proof of non-refundable fee of rupees 5 lakhs and shall pay rupees 50 lakhs within 15 days of intimation for registration. Certificate of registration once issued will be valid for 5 years. Renewal of registration. Application shall be made 6 months prior to the expiry of registration date in Form A, along with non-refundable fee of 5 lakhs, and within 15 days of intention to renew shall pay rupees 50 lakhs. Then form of registration certificate. Board may seek additional information if satisfied that it has adequate infrastructure, manpower, and it may grant or renew certificate of registration in Form B within 60 days of receipt of such application. The board may refuse the registration if the board is of prima facie opinion that registration certificate ought not be granted. It shall communicate the reasons for within 45 days of the application if it wants to deny the registration. Applicant to submit reply within 15 days. Thereafter, within 30 days, IBBI shall either grant or refuse the registration. Suspension or cancellation of registration. The IBBI may suspend or cancel on any of the following grounds: that it has obtained registration by making false statement, misrepresentation, or by unlawful means, failed to comply with requirements of regulation or any other rules as may be prescribed by IBBI. Reasonable opportunity to be given before suspension or cancellation of such registration. Now, surrender of registration. The information utility may apply for surrender of registration, detailing the reasons therefor, details of pending and ongoing activities, details of exit management plan. IBBI shall, within 7 days of receiving application, put it on its website and invite objections to be submitted within 14 days. Within 30 days from the last date of submission of objections, IBBI may approve surrender and it may order for discharge of any pending obligations or continue such obligation for certain period. The IBBI shall place the fact of such surrender on the website of the IBBI. Appeal against the order of IBBI may be preferred to National Company Law Appellate Tribunal within 30 days. The obligations of information utility are as follows. It may create and store financial information in a universally accessible format, accept electronic submissions of financial information from persons who are under obligation to submit such information, meet such minimum service quality standards as may be specified, get the information authenticated by all concerned before storing such information, and furnish such information as may be specified by regulations. The information utility shall have interoperability with other information utilities. The data provided by information utility is accepted as a legal evidence by National Company Law Tribunal or debt recovery tribunals. Procedure for submission of financial information. Any person who wishes to furnish financial information to information utility or access the information shall pay reasonable fee, which shall be placed on the website of IU, or any increase in the fee shall also be placed on the website of the IU 3 months before such increase. The financial creditor shall submit financial information and assets created as charge as well. It may be noted that RBI wide circular dated December 19, 2017 advised all banks to adhere to these regulations. Operational creditors may also submit financial information. Process of operations at information utility. The information utility shall set up governing board. Before submitting information, person or entity shall enroll with information utility as user by producing identity documents like Aadhaar, PAN, SIN, etc., and after verification user ID will be provided. Banks or financial institutions normally create a super user, that is covering all its branches, and inform all their branches. The data to be submitted in form C. The IU shall preserve the data for a period of 8 years. After commencement of CIRP, the resolution professional to submit information regarding proceedings of the meetings, records, etc. for storing. The information utility to provide an annual statement of all information pertaining to that user at free of cost. The information utility to enable access to information only to parties connected with the debt, that is resolution professionals, liquidators, adjudicating authorities or IBBI, etc. An aggrieved person against the order of IU may lodge complaint through grievance redressal mechanism enabled in the website. IU would resolve all the grievances within 7 working days and inform the complainant. In case complainant is not satisfied, the complaint may be escalated to grievance redressal committee of information utility, which would examine and resolve the dispute within 10 working days. If not satisfied with the grievance redressal committee decision, the matter may be escalated to IBBI. Students, it is pertinent to mention that creation of information utilities under the IBC mechanism is very good attempt. It may be noted that most of the civil suits in India are delayed because of non-availability of information as evidence. The information utility system solves this problem by storing and supply of relevant information which is a legal evidence. Because of this, all the processes under IBC can be expedited. In the next lesson, we will discuss about the various penalties and the offences under the IBC. Thank you, students.